Recently, you have witnessed international turmoil when Russia declared two new countries out of the territory of Ukraine. So, meaning thereby, Ukraine has been now divided into three countries as per the declaration by Russia. That is, one, Ukraine itself. The other two new territories which have been declared as independent countries by Russia are Luhanshk and Donetsk. These two new territories have been carved out from the existing territory of Ukraine and declared as two new independent countries by Russia. The other part of the international community has not till date accepted the declaration of these two new countries. The declaration of Russia as two new countries out of the existing state of Ukraine is not yet acceptable to the international community. Point as a law student is, what is the law on this issue? Whether one sovereign nation can declare the other parts of the countries of the sovereign states of the other nations as independent countries. What is the law? What is the international law on this issue? You must have also the curiosity to know about the international law. There is a principle known as recognition. As you are well aware, international law is not a codified law. It has been developed with the passage of time, with the acceptance of different norms accepted by all the international community. What is this international community? This international community is the society or a club of all the sovereign nations, and they have accepted certain norms to be accepted by all the international members of the community. That is called international law. And in the international law, one of the concept and the principle developed is recognition. Now, what is recognition? Recognition means one sovereign nation who is a member of the international community may allow the other member, a new member, into the international community by giving recognition to that state. But point is, to which particular part of the state or to a state the recognition can be granted. There are established norms. Even the UN Charter has accepted that there are four basic requirements for a state to be given the recognition by another sovereign state. One is that state must have populace, the population or the people of that nation. Second, it has a government. Third, it has a territory. And fourth, it has a sovereignty, means it is independent. So if these four conditions of statehood are there, then the other existing sovereign state may give the recognition to the new state and allow that new state to become a member of the international community. So this is the basic principle. There are then two different modes of recognition. One is de facto, another is de jure. De facto means, again, I am not explaining in technical terms of legal terms. I am just discussing with you in a simple way so that you can easily understand what is the meaning of these technical terms. De facto means a temporary recognition, meaning thereby one existing sovereign nation may give a temporary recognition to the new state which fulfills the conditions of statehood. Now take an example that a state has been established fulfilling the conditions of a statehood, but the recognizing state is not satisfied that whether these conditions, the essentials of statehood, are permanent in nature, or character of those conditions are permanent in nature. Then the recognizing state may give de facto recognition, that is a temporary recognition, so that they may wait for some time to see whether this new state will continue towards permanence or has attained some permanence in the international community by having the essential conditions of statehood. Second is de jure. De jure means a permanent recognition. De jure recognition may be granted at the initial stage also. The recognizing state, if satisfied that the conditions of statehood are fulfilled by the new state and those are permanent in character, permanent in nature, then de jure recognition can be given. Or first at the instance, suppose a de facto recognition is given. Subsequently, when the recognizing state found that the conditions are fulfilled and these are having the permanent in nature, then the recognizing state may convert that de facto recognition to a de jure recognition. So, next question is, what is the effect of de facto recognition and what is the effect of de jure recognition? In case of de facto recognition, the recognizing state and recognized state cannot develop their diplomatic relationship. They cannot have the benefit of privileges and immunities under the international law. But in case of de jure recognition, both the countries can develop their diplomatic relationship and they have the benefit of privileges, immunities under the international law. And the next and the most important question, which now for our discussion, is what are the effects of recognition? Suppose, as you are now aware, Russia has given the recognition to these two new countries, but rest all other members of the international community have not given the recognition. What is the effect in law of recognition by one state and effect of non-recognition by other states? First is diplomatic relationship. The recognizing state and recognized state, they can develop their diplomatic and consular relationship, and ultimately they are entitled for all the privileges, immunities, etc. under the international law. But between the recognizing state and recognized state. Second is stability at home and prestige at abroad, meaning thereby, by way of recognition, if an existing sovereign nation is giving the recognition to a new territory as an independent country, it means it brought into a stability within the new state, and it also gave prestige outside the nation, that is in among the international community. And third is access to foreign aid, loans, succession to the property, to the other assets, and trade. So meaning thereby, once a recognition is given, then the recognized state has the benefit of taking loan from the international community, has the benefit of having a trade with the international community, has the benefit of succession of the properties, of the assets, and the immunities in the international community. I'll just take an example. Suppose a recognizing state recognize the new state, like in the present case, Russia has given the recognition to these two new countries. Then these two new countries have the access over the airspace of Russia, have the access of international waters of this recognizing state. But in case of the other nations which have not granted the recognition to these two new countries, they may not have the access to the airspace of those countries, may not have the access to their international waters. So, all these benefits may accrue with the recognition, and conversely we can say, in case it is not recognized by the other members of the international community, these are the indirect way we can say the effects of non-recognition, that they are not entitled for sovereign immunity, they are not entitled for having access to the properties of their predecessor state, they are not having the access to their international waters, they are not having the access to their airspace, and so on and so forth. Thank you very much.